Hi, this is Brian with Geeking Akron, having a bad hair and, well, everything else day. And of interest today is a couple of court cases around the nation that have made some headlines in the tech circles, primarily because of how they bear on privacy and the way we can give information both in and out of the government, and also how we can protect our own, sometimes even if we can. The first case is out of the State Supreme Court of Arizona from a case called Lake versus the City of Phoenix, and it relates upon the Freedom of Information Act requests when getting information out of government. Now, historically what happens is that when you make a Freedom of Information Act request, it is usually passed along in paper form. However, a lot of documents, especially in this day and age, are created on computer, and there is some data that historically has not been passed on along with whatever prime data is being requested, in this case called metadata. Metadata, for those who may not be familiar with the term, is small bits of information, or sometimes even large bits for that matter, that are attached to a file, almost any file actually, that is usually related to the operation of the computer and being able to, and how to handle that data once it's loaded into a program or an operating system. But very often, depending on what you're using, it can contain other rather pertinent pieces of information. Now, the case in question, without going into too much of it, basically was a civil service employee was denied a promotion and claimed that a vendetta by a supervisor caused the supervisor to backdate certain documents and make it look bad, and so he got passed over for review, and that got spun into an argument as to whether or not the metadata should have been supplied along with the actual document content when they did a Freedom of Information Act request on that info. And the reason that he wanted it is because very often, again, depending on the program and the type of data that was stored on it, this stuff can contain revision dates, revision history, redacted content. It can have the people's names and computer information of the people who had accessed and modified or even deleted certain documents in certain cases. And it can have the names of the computers, servers, networks, business names, anything else that you can think of attached to these documents in this metadata. Now, when you print out these documents, obviously you don't see this stuff, not by default anyway, but most programs actually create this metadata that goes along with it. Well, the City of Phoenix didn't want to hand this stuff out, but it looks like their Supreme Court is saying, they requested the document, and the metadata is actually a part of that document and should be supplied. So, there is a similar case also in Washington State that is looking into this sort of thing, and it looks like there is a possibility that this could be a rather nationwide thing. It's kind of a bellwether case. Now, I'm certainly no attorney, wouldn't even want to be. Would like to make the money, but that's another issue. But basically, there's a lot less that can be hidden now by the government if a Freedom of Information Act request has been made. And the other thing is that you could ask, well, hey, why don't people just delete the metadata after they create whatever program it is that they've created their document on? Well, actually, that would be considered destruction of information, and they can't do that. So unless they want to have custom written office programs and things like that doesn't create any of this metadata, it's pretty much going to be there. So that's on the good side of the whole privacy issue, which I'm talking about today. Now, the other case isn't exactly so hot when it comes to private individuals, businesses, corporations, and things like that. Federal judges ruled that email, documents, and almost any other data stored on third-party physical servers is not actually completely protected by the Fourth Amendment in terms of search, seizure, privacy, whatever. Basically, what it comes down to is not that it has no protections of privacy, but from what I gathered by reading the article, it says that if the stuff is being stored on another server by a third party, whether it's Google, Microsoft, Hotmail, in any instant messenger services, cell phone, Verizon, Sprint, AT&T, whoever it is you want to talk about, or any private internet service providers, if the stuff is there, and the government gets a warrant to look at this information, they are not required to contact you as the owner of the information that the stuff is being looked at. They have to serve the papers and notify the ISP, but they do not have to actually talk to you that they're looking at your data. So it's going to be a fairly interesting dance, I think, for the next little while this one gets hammered out. The judge. Here's the quote from the judge in the opinion, Judge Mossman. And it says that when a person uses the internet, the user's actions are no longer in his or her physical home, and in fact he or she is not truly acting in private space at all. The user is generally accessing the internet with a network account and similar storage owned by an ISP like Comcast or NetZero. All materials stored online, whether they are emails or remotely stored documents, are physically stored on servers owned by an ISP. When we send an email or instant message from the comfort of our own homes to a friend across town, the message travels from our computer to computers owned by a third party, the ISP, before being delivered to the intended recipient. This private information is actually being held by third-party private companies, and those are the only people that they are required to notify. So, for the very security-minded individual, business, company, whatever organization that you happen to have, I could actually see server hardware picking up maybe just slightly in the view of this case. And I mean, not too much, because even if you have it on your own system in your own house or your own business, once they get a warrant, they can get it anyway. But the whole point of this particular opinion is that they don't have to actually tell you about it. But I do know some people, some fairly libertarian-minded folks, that are going to take quite a bit of an exception to this one, and they may look at things like the emerging cloud computing services and things that are going on right now, and may have a askance look at it now. There's this possibility that people might want to actually entertain hosting and rolling their own kind of a pioneer-like fashion. So who knows what will happen. Anyways, a congenial hat tip to Slashdot.org for both of these news stories and references. And on a completely unrelated note, I would like to thank everyone who has sent in messages of doing well health-wise and things like that, and everybody's doing a lot better, and we thank you very much for that. And just a last anecdote, I was over at a gas station a little bit ago. Here it is on All Hallows Eve, as it were, and the voice of the pirate costumed gas station attendant on the intercom over and above the gas station pumps was, "Pump 2, you need to reslide your card. Arr." Okay, I thought it was good. Anyways, have a good evening. Thanks a lot.